an eye up. I am hear me. I've no way of knowing this unless I see people coming off air. So welcome to today's webinar. It's one of them on maternity and paternity. We've seen ages of children, women having babies, and giving birth to children changing over the past few years. And if we look, there's no particular age when somebody conceives now. You can have twins at 60 with fertility treatment if you want, I think. The role changes at home as well. We're seeing lots of people change the role at home, and you know, we're seeing a lot of people have women now that are the main breadwinner in home. Lots of homes have that, and also there's lots of same-sex partnerships now. Lots of impact on how people take maternity leave, how they take it, what they do, and etc. So the other thing is, when there is pregnant anymore, and there's a duty of care from the employer to know and protect the employee. So what we always recommend is that you look at your policies and procedures. I'm not looking for a huge maternity policy at this stage. What I'm looking for is a statement that protects my client from having a tribunal or a pregnancy discrimination case. And to do that, prevent that, we need to know when somebody is within the workplace. What is the maximum lifting? What is the recommended lifting for a woman when she's not, when somebody's pregnant? We won't know whether the pregnancy is troubled, if it's a healthy pregnancy, etc. We need to do a risk assessment when we know somebody's pregnant, to know what they can lift and to know what environment they can work in. Think of the care sector, for example. If I work in a care home, I become pregnant, I don't tell you, and then I'm working with adults or the elderly through no fault of their own that are violent, they hurt me, and I lose the baby. What have we got in place to protect ourselves as employers and managers? What I would like in your policies and procedures as a defence statement to protect you, and especially the HR people here and the managers and the directors that are listening to me, to protect you in your job. I want a statement that says when a female employee becomes pregnant, she lets us know at the earliest stage possible so we can make the health and safety standards necessary for her to do her job. And I've protected you straight away with that statement, because I'm delegating responsibility and authority to the member of staff to tell me written at the earliest stage that they are pregnant. So I'm not going to dismiss them without knowing they're pregnant. I know that I have to do risk assessments, and I know I should have health and safety standards in place to protect them. They need to tell me, then I implement them. I don't want to be one of those people that dismiss somebody without that statement in place, and then I've got to defend myself. And then we get a lot of questions about maternity and paternity. And, you know, you've got to remember as well, the law has changed, things have changed, society has changed. So are two people that are in a same-sex relationship, are they entitled to paternity if one of them gets pregnant? Yes, they are. And then what happens? I've got a Jeremy Kyle moment here for you. What happens? Let me give you this scenario as well. These are just some of the questions we get on our advice line. And we take 60,000 calls a week, we do. So you can imagine how many calls we get. So same company factory scenario. Let me give you this. I work for you. This is your Jeremy Kyle moment for today. I work for you and I work in your factory. I'm a hard-working individual, and my husband works there as well. I become pregnant by my husband, but shortly after we split up. I'm in the early stages of pregnancy when I get clicky with somebody else that works in your factory. And then what happens is I move in, or he moves in with me. Can you tell me now, asking you, the employer, HR or manager, when I give birth, which member of your staff is entitled to the paternity leave? And what we would recommend to our client, for argument's sake, in the sake of a couple of weeks, manage it between them. But what we would say is that they're both entitled, because one actually made the baby and the other one is contributing to the upbringing of the child as well. So for argument's sake, we would say give them both it. So policies and procedures, what you have to remember, in some companies, some might give better favours in there than others, and some might. And some countries are so behind the times. There are certain companies that actually dismiss countries where they dismiss you actually if you are pregnant. But that's not in this case in this country. So what I would like in your policies and procedures is to just have a look what you've got in place. Have a look what your statement says. Does it protect you from somebody saying they dismissed me when I was pregnant? Have you delegated the responsibility and authority to that member of staff to let you know when they're pregnant? Have you got risk assessments in place? Do you know what the maximum lifting for a woman when she's not pregnant is? That if they are pregnant is 0. So you need to do risk assessment just to base it on whether they are able to lift or not. And we need health and safety standards in place, and we need to create this paper trail. So this is the codes and interpret statutory paternity pay. What I will say to you is that after this presentation today, these slides will be uploaded onto YouTube and the recording as well, which is a bit touch and go at the beginning, but the recording will be there as well. So don't try and struggle to write notes here. Have a look at those codes. They're there for you for reference, okay? So ordinary maternity leave is the time the employer must write back within 28 days, setting out her return date. And the employee can change commencement date by giving 28 days notice. There's paid reasonable time off for antenatal appointments and the right to return to exactly the same job. Okay, so that's the requirements by law. Additional maternity leave, all employees, whatever your requirements are, write that into your weeks off. This is health and safety side, must take 2 weeks at least after birth. This is the health and safety side of it. Somebody can hemorrhage, somebody can have a complication, so it's got to be at least 2 weeks after the birth. During maternity leave, normal terms, additional maternity leave. They must advise 15 weeks before the expected week of childbirth, and they must confirm their pregnancy, date of arrival, medical certificate, date of attended maternity leave, and no earlier than the 11th week before the expected date. We've got statutory maternity pay. This is the legal minimum the employer normally has to pay the employee while they're on maternity leave. And the qualification for SMP, at 15 weeks, they must have been working for you, for the employer, for 26 weeks and earning enough, £109 a week. SMP, for the first 6 weeks, 90% of their earnings before tax. Remaining 33 weeks is £136.78, or 90% of earnings if that's less. Don't qualify, advise them to seek help, and they might be entitled to maternity allowance. So, maternity redundancy, a lot of things can change if somebody's taking 52 weeks off. So, time off for somebody, it's a great way when you're for maternity, the OML and the AML period, and they can agree, you can agree with them, and you might want to write something in your contract here that they are able to have up to 10 keeping in touch days. I just think this is a fantastic thing to do for the employer and the employee, because, you know, I see so many people see it, maternity, pregnancy, paternity leave, as negative, and it doesn't have to be. What you are going to get is a really good dedicated employee in lots of cases where they'll come into work, they work for you, they get pregnant, you get a temporary worker in to cover them while they're off, they come back to work and they really do need this job, they're keeping this job, and it's horrible when you've had 2 weeks off sick, you think you've missed off something, don't you? Some people do. So imagine having a whole year off work. What's happened while I've been away? So if we arrange, 10 keeping in touch days, then they've got the chance to come in work, earn a bit of extra cash whilst they're off, and also keep on top of the training, keep on top of what's going on within the workplace, and new starters get used to seeing them around as well. I just think these are amazing days. Lots of companies have done these for years. I know Starbucks is one company that have always had keeping in touch days. It doesn't bring the maternity to an end, and are losing their entitlement to SMP either. They get paid above this. There's no automatic entitlement to be paid. However, this can be agreed, and I think it's a great opportunity for the employer to pay them a bit of extra cash to get them buy-in to come back. And, you know, what about reasonable contact anyway from time to time? Does not bring the maternity to an end. Remember that. So now we're talking about additional paternity leave, and I've got a summary here about paternity leave and additional paternity leave, and then I'm going to lead into paternity leave. What we know at Peninsula is a recent study has shown that less than 1% of men are taking up their entitlement to additional paternity leave. The entitlement to additional paternity leave was introduced by the government in 2011 as part of its eternal plan to provide a better work-life balance for the UK employees. So it's only been available for 2 years. Well, it'll be a little over that next year, and recent decisions to change entitlements for working parents mean that it will be abolished in 2015 to be replaced by an entirely flexible leave system. So until then, what do we know about it? Well, additional paternity leave is a separate entitlement from the entitlement to ordinary paternity leave. Ordinary paternity leave is for a maximum of 2 weeks, which must be taken within 56 days after the birth. An employee will only be eligible to take it if they have 26 weeks service by the end of the 15th week before the baby is due. The same length of service criterion applies to additional paternity leave, but this time a maximum of 26 weeks leave can be taken. The earliest point at which additional paternity leave can start is when the baby is 20 weeks old, and it is also a requirement that the mother of the baby has returned to work. This means that the mother and the father cannot take their respective leave periods at the same time. Parents would have to use other entitlements if they wanted to be off at the same time, example annual leave or parental leave, but even then there are restrictions to do that, depending on when the leave is to be taken. The mother of the baby is effectively transferring the rest of her leave over to the father. One of the potential reasons why around 78, whilst many companies offer a good maternity package of, for example, 6 months at full pay and 6 months at half pay, very few will have considered offering an enhanced pay entitlement for fathers who wish to take an extended period of time off to allow the mother to go back to work and still keep childcare within the close family. Typically, it is the father who earns more than the mother, so most couples choose for the mother to remain off work and the father to continue earning his normal salary. There is indeed no requirement for employers to offer any payment in excess of the statutory minimum in terms of rate of pay and its duration. Statutory payments for fathers on additional paternity leave also stop at the point that the mother's maternity leave would have stopped. If the leave had remained with the mother, so at the point of 39-week point after the birth, statutory payments will stop and a father on additional paternity leave will receive no pay for the rest of the leave period. From 2015, the government are set to introduce shared parental leave, which will mean that parents will be able to break up their periods of leave down to a minimum 1 week period, which they can alternate for a maximum 50 weeks should they choose. Ordinary and additional paternity leave are not only available to fathers of a baby, remember this, but also to employees who are married to or the civil partner or the partner of the child's mother or adopter. Whatever the relationship, the employee must have or expect to have responsibility for bringing up of the child. So that's additional paternity leave. This is the basic paternity leave. Qualifying conditions: 26 weeks continuous service, 6 weeks of the birth. The right is to childbirth or as soon as it's reasonable, practicable for employee to do so. Employee can change commencement date with 28 days notice. Have the responsibility of child's upbringing, biological father, husband or partner, same sex also, so remember that. Worked continuously for their employer for 26 weeks, ending with the 15th week before the baby is due, or notified of being matched with adoptive child. 1 week or 2 weeks paid paternity. Remember, you want to write this in your contract, not to be taken as odd days. So that's £136.78 per week for paternity leave. When responsibility for a child, including adoptive parents. The qualifying service is 1 year adoption or up to 18 years for a disabled child. Include in your terms and conditions that the requirements for your business take in blocks of 1 week, 21 days notice, and leave limited to 4 weeks per annum. So that's something we would recommend. Some sort of mention of parental leave in your handbook, how they take it, what your requirements are, and what you want them to do, and how they would action that, you know, what the requirement is, who they would go to have it authorised, and what the notice period is. We would like to see some mention of that in your handbook. So these are some of the questions I've had about family-friendly rights. An employee has an emergency situation to deal with in relation to one of his emergency. For this right to apply, the employee must inform you as soon as reasonably practicable why he is absent and how long he expects the absence to last. There are various circumstances in which this right would apply, including when a dependent is taken ill or when there is a breakdown of care arrangements. A dependent is an employee's parent, wife, husband, civil partner, child, or someone who lives with the employee as part of the family who is not a lodger, boarder, employee, or attendant. And I also would say in these cases we've seen it, a very close family member that they rely on and look after. Because you refuse to let the employee avail himself of his right, the employee could bring a claim against you at a tribunal because the law sets out specific enforcement of this right. If the tribunal found that you unreasonably refused to allow the employee to take time off for dependents, they are entitled to award the employee compensation, the amount of which will be what the tribunal finds just and equitable in the circumstances. The employee would have to make the claim within 3 months of the time off being refused. If this situation doesn't lead to a tribunal claim, it may nevertheless be that the employee files a grievance because of the refusal, which you would deal with under your company's grievance procedure. The law states that any time taken as time off for dependents is unpaid. However, you should check the employee's contract of employment to see if there is a contractual provision for pay during this period. And it's something I do talk about. Lots of companies pay dependents leave, but they pick and choose who they're paying. They pay a woman that's been there for 10 years because she's dedicated, but they don't pay a woman that's 18 that's got a baby and who's only been there a week. That's discrimination, age discrimination. If you're going to pay everybody. But if you're not going to pay, don't pay anybody. And remember, this comes under, and it falls under absenteeism. So make sure that you have something written in place that it says either unpaid or paid. And I do actually think that, you can, if you have unpaid rule, that you can allow your staff to make the time up with holidays or make the time back. But remember, have an agreement on that with them to do that. There is no predetermined maximum time that can be taken, but remember the law states only reasonable amount. I wish they had an equation there for what reasonable is, because I have not got a clue. It really is a grey area. So, dependence leave. An employee is entitled to this leave unpaid from day one. Back to return to work interviews, it's about keeping an eye. I don't know your staff, you do. You work with them every day. I'm just telling you what I would do, what I think's right with employment law, where I can see troubles later on. But I don't know the personality of your business. I do not know your staff. I can reflect that in what I write for you. But at the end of the day, you do know your staff. And you know when somebody's taking the mickey, but what I say is continually assess it, do return to work interviews. Remember, dependence leave falls into absenteeism, monitor it under absenteeism. My opinion, I wouldn't pay. I would have it as unpaid leave, and I would, if somebody's struggling financially, give it them as extra holiday, give it them as unpaid, or, I'd give it them as, and say make the time back up, but I'd monitor it. So, there to take necessary action. There's just a summary of the examples. Provide assistance to a dependent who falls ill, gives birth, or is injured or assaulted. To make arrangements for the provision of care for a dependent in consequence of death of a dependent, unexpected disruption to care arrangements, to deal with an expected incident involving a child of the employee, which happens during the time frames that an educational establishment should be caring for the child. So you might see this as well later on when a child, is unruly at school. I've had a few of those in my time, of my own children, I must say, where you get called unexpectedly because a child has bitten a teacher at the age of like 4 and you have to go in and sort that out, So that's the type of thing that I'm talking about when the school's called you in. So, holidays and maternity leave. What happens with that continue to accrue during both ordinary maternity leave? This is because legislation stipulates that an employee who takes maternity leave is entitled to the benefit of all the terms and conditions of employment which would have applied had she not been absent. Because maternity leave can span a significant amount of time, the question arises about what happens to the employee's entitlement to annual leave that she accrues during the annual leave year in which she is absent. Theoretically, maternity leave could commence as the annual leave year commences and end as the leave year ends, leaving no room for the employee to take her annual leave entitlement. It is clear that an employee cannot be on maternity leave and annual leave at the same time. Although in theory the dates could clash, it will be a rare occurrence, meaning that usually maternity leave spans 2 annual leave years. So, employers need to be proactively start with the remaining untaken annual falls into another annual leave year. The employee may wish to enter maternity leave early and take annual leave up until the date that her maternity leave would ordinarily have ended. The actual amount of time away from work would remain the same. The part of it designated to annual leave should be paid at her normal rate of pay rather than statutory maternity pay. I know that that's something that I did. So, I ended my maternity leave early and then I took my annual leave up until the date that I was due to return. And that helps financially in some households as well. So I think that's a pretty good idea. It helps both parties. If the employee takes annual leave before her maternity leave was intended to start, and she gives birth while still on annual leave, the annual leave will stop. This is a good question because we get asked this. The annual leave will stop and maternity leave will automatically be triggered. This is because an employee cannot be on annual leave and maternity leave at the same time. So here's another question. This is about flexible working now. We have an employee due to return from maternity leave in November who has requested to change her part-time work pattern, meaning she will be starting later. We will not know if this is workable until it has been in place for a few weeks. Do we have to agree to it? Well, what we're seeing at the moment, I will add, is we're seeing a lot of different working patterns. Look, I don't know about you, if you have to head into cities to go and work somewhere. I live in North Wales, and quite often I head into Manchester to go to our head office. And I have to say to you, I've worked in London as well. I work all over the country. I even work in the Outer Hebrides. Everywhere there's a piece of land I go. But I have to say that go ahead into Manchester or Birmingham or London, the traffic is an absolute nightmare and it's stressful. If I want to miss the traffic going into Manchester, I have to leave at 7 o'clock in the morning to get there for 9 o'clock. And it's only a 50-minute journey to get there when the road is clear. And it really, really frustrates you. Now, if there's an accident or a traffic jam, it's so annoying. So sometimes what businesses are doing now, and also because of the sheer weight of traffic on the roads, is they're actually looking at different ways of working within their companies and also cost-effective ways. I know for sure for me, I do get more work done when I'm at home. I don't get interrupted by people. I don't get asked questions. I'm not asked about editorial. I'm not asked about anything. I can just get on with my job. And that is what I like. So I'm a chatty person, so I like to chat, but, you know, I need to get my work done. And so when I'm working from home, I get so much more work done. And I can work it within my life and my time as well. And it works perfectly for me. I know that can't happen in lots of companies. But what you could do is you could look at the different ways of working. People work with compressed hours and they get a happier workforce because people are working either 3 or 4 days on and then 3 days off or 4 days off, and they get an amazing amount of time off and they absolutely love it. I know Airbus is one company around where I live that actually instigates that, and I came across compressed hours back in about 1989 in the casino and the media where they would do that as well. Compressed hours are brilliant. What we're also seeing is people are looking at the job role and thinking, does it really have to be a 9-to-5 job? Can we operate flexi time, which can be sometimes hard to manage? But can we look at maybe working and changing the shifts so that people might work evenings rather than, so an ordinary role as a personal assistant, could we actually operate that role as a job share and have one person working during the day, during the school hours, and then have somebody covering all the paperwork in an evening and doing it in the evening to get all the paperwork done? And I've seen companies where they have 2 part-time personal assistants, one to answer the calls during the day and then one to do all the paperwork in the evening, and it works. We've seen people having term time working, and what you're going to get is if I've got loads of children, which I have, and you're offering me a term time job, that is a gemstone, and I will not leave that job and I will do my best to keep it. So what we're going to get is commitment. So look at different ways. Don't sort of close the doors on it. Have a look and assess what works best for your company, and look at the roles as well. What you might get as well is you might get a student that's doing an IT degree or a computer degree or an analytical degree. I'm making them up as I go along here, you know, but some sort of degree that benefits your business that might be able to work in the evenings for you on a job that you were going to advertise during the day, and you get the best of both worlds. So let's have a look at this question. So I bet you've forgotten the question now, so I'm going to repeat it. We have an employee due to return from maternity leave in November who's requested to change her part-time work pattern, meaning she'll be starting later. We will not know if this is workable until it has been in place for a few weeks. Do we have to agree to it? If the employee has at least 6 weeks service, she's entitled to seek a change to her working pattern via the statutory right to request flexible working in relation to the hours she will be working when she returns from maternity leave. Remember, not the automatic right to it. They have the right to request it, not the automatic right to it. This right is only available to her if she has not made a previous request within the last 12 months. She does not have the right to work flexibly, just the right to request a change to hours or location of work, and you are under a duty to consider this request. Do it all in writing. Okay, that's your defence. The final decision therefore lies with you. This means that the control over the employee's working hours remains with you, and from a wider perspective, you don't have every eligible employee deciding on their own working hours. Right, remember this as well. Keep a paper trail, and when you agree to a change, you need to change somebody's terms and conditions to reflect that change. If the employee hasn't requested the change by making an application under the statutory procedure, you should encourage her to do so. You will need to hold a meeting with her to discuss the application, and she will need to have considered the effect that the requested change will have on you and how the effect might be dealt with. If there are good business reasons why the proposed change to working hours would not be workable, you're entitled to refuse the request. However, you can only refuse for one of 8 reasons, including these below. Okay? The burden of additional costs, the inability to recruit extra staff, and the inability to reorganise work amongst existing staff. If you do envisage that the amended work pattern will work, then you can refuse the request in its entirety. Alternatively, you may think the employee's suggestion may work with a couple of alterations that the employee agrees to, so you can attempt to rework the original request. This is just one little thing just to point out to you. When somebody say, I work full-time, but then I want to request to work part-time hours, and I choose a Monday, Tuesday, be careful about bank holidays. When you rework the terms and conditions, remember a good idea would be include the bank holidays into their normal holiday entitlement. You don't want to pay over and above, do you? Also, it is also possible to agree a temporary change to the working pattern to effectively give you and the employee a trial period to see how the business runs on the amended pattern. Normally, any variation to hours agreed on will be a permanent change, unless it is expressly agreed between the parties that it will only apply for a short period of time. If the trial period is agreed, the employer and the employee must agree to delay the normal time limit for making a decision on the change in hours and specify the date the extension is to end, i.e. how long the trial period will run for. Therefore, you will have the opportunity to see how the amended pattern works in practice and review it at staggered periods. You will, however, still retain your right to refuse the request at the end of the trial period, permitted the refusal is one on the prescribed grounds I said before. So, excuse me, that's flexible working hours. So remember, just to have a look at ways of working, and remember you can have a trial period with this. You don't automatically have to say yes. You can agree to trial it, but remember always the paper trail I'm talking about. So just some changes that are coming in that have been spoken about. Extended rights for new parents. What are the new rights? Excuse me, you have to bear with me, I've got a bit of a cough today. Under the flexible parental leave system, parents will be able to share 50 weeks of leave between them after birth or adoption. Full amount of leave is for a year, but the mother will have to take her 2 weeks compulsory maternity leave first, so the remaining 50 weeks can be shared. It can be broken down to small chunks and time can be taken alternately for each parent. The right to flexible working will be made available to all employees, not just parents and carers. Flexible parental leave will be a nightmare for employers planning in and out of situations, unless it's managed properly, that is. Planned implementation dates for all this is 2015, except the flexible working part, which is expected next year. Adoptive leave changes. The current qualifying period required to be eligible for adoptive leave will be removed, so employees will be entitled to take adopted leave from day one of employment. Currently, employees need 26 weeks service at the point they are matched with a child to be entitled to adoption leave. Antenatal appointments. Fathers will have a right to unpaid time off to attend 2 antenatal appointments, which I think is really fair. Surrogacy. And remember, with this, same-sex partners as well, I would imagine, will be included in that. Surrogacy, intended parents of a child born through a surrogacy arrangements. We frown on the surrogacy in this country so much, and yet they don't in other countries. So we're going to see this, we're going to see society change so much to embrace surrogacy, adoptive leave, maternity, paternity. It'd just be a regular thing, and it's all about control and management in the workplace and what you've got written down. Remember that. Intended parents of a child born through a surrogacy arrangement who meet the criteria to apply for a parental order will be eligible for statutory adoption leave and pay if they meet the qualifying criteria. And for flexible parental leave and pay if they meet the qualifying criteria. They will also be eligible for unpaid time off to attend 2 antenatal appointments, which is fair. You know, fair dues for anybody. So we're seeing these changes in 2014 and 15. Remember, I'm here to protect the employer. I'm here to protect the employer, managers, HR, and proprietors and trustees. I'm here to help you manage all this. I'm here to help you put things in place that help you manage it, to help you assess the situation and get it right without ending up in a tribunal. Currently helping over 27,000 businesses throughout the UK. I know that you're aware of that, taking 60,000 calls a week from employers, managers and HR. And we do help people. We write things in place that people don't think about. The statement about maternity, let me know when you're pregnant rather than me guessing, you know. So I'm sorry about the sticky start at the beginning today. I'm so sorry that it took ages to start, well, 3 minutes in total, which is ages when you're listening at the end of a phone line, isn't it? We had a problem with the GoToWebinar system. It is Friday the 13th. I hope you have a very lucky Friday 13th today. We have a few more webinars coming up in the next few days, and we'll finish with the webinars on the 19th of December. The ones coming up next week, we've got part-time workers on the 17th, we've got underperforming workers on the 18th, and we've got discrimination on the 19th. I hope that you find and you're listening to me on next week, and if not, I hope you have a very happy Christmas and a happy New Year. If you'd like to access any of my previous webinars or recordings or slides, you can on www.youtube.com/PBS Press Office. If you'd like to contact me, and this is me, this is my email, it's not somebody answering my emails for me, this is my email address. If you'd like to speak to me directly, you'd like some free advice, you'd like me to write some editorial for you, you'd like me to feature at an event you've got, I will do that for free because Peninsula pay my wages for that. If you'd like me to host an event or even organise for an event for your clients where I will talk about employment law and any particular topics that you think are relevant for your clients, we will do that for free. That means even provide the hotel. If that's of any interest to you, contact me, amanda@peninsula-uk.com. And if you'd like a free advice call and you're a non-Peninsula client, you know, contact me or Lee on 0161 827 9915. I know that's not free phone, so ask us to ring you back straight away or contact me via email. This is webinar 0030, and for the Peninsula clients listening to me today, remember, you've got the advice line there 24/7, 365 days of the year. That means that you can ring us. We're there to hold your hand, to help you out, to help you with any aspects of employment law. So don't sit there struggling to write letters or adverts or policies or procedures. That's what you're paying us for. I don't want you to do that because this is what we offer you as a service. And then if you do have any issues or problems or tribunals, remember, we insure you for that. So I hope I've helped you today. Excuse me about my cough. I hope to speak to you again shortly. And remember the 3 other webinars next week. Thank you very much for listening to me today. And it's goodbye from me.